All-inclusive current affairs for prelims 2021 Polity Class 4. This video is in English. हिंदी वीडियो भी हमारे YouTube चैनल पे अवेलेबल है. Simultaneous elections. Simultaneous elections does not mean that the whole nation is going to vote simultaneously on the same day. No, phase-wise polling will happen. Okay. What it actually means is that the voter votes for center and state on the same day. Okay, you have to vote for the Lok Sabha and for the state legislative elections on the same day. When you go to the polling booth, there will be two EVM machines in front of you. On one you will choose your MP, on another you will choose your MLA. You are simultaneously choosing the two representatives. Okay, so just be careful about what how UPSC is framing the sentences. So with this, the exam relevant topics could be the election expenditure. See, basically BJP is pushing for this simultaneous election. So UPSC in prelims can ask questions, can frame questions on the arguments. See, BJP says that with simultaneous election there will be less election expenditure. MCC will be applicable for less duration of time. Okay, these are the advantages. So UPSC can frame question on these advantages. Similarly, the disadvantages can be on accountability or the term of Lok Sabha. Right. So again, UPSC can frame standalone questions on these topics. So let's look at them. Election expenditure. Remember one thing, that whatever election expense limit is there, that limit is on the candidate, not on the party. Okay, BJP or Congress as a party, they can spend any amount of money that they want. Okay, the limit that you hear in news, 70 lakh rupees limit, that is on the candidate. Be the candidate and be it a independent candidate or be him a ticket holder of any party, that does not matter. Right. There are also some star campaigners. There is no expense limit on such star campaigners as well. We will look at star campaigners in the next page. So the political parties, they need to tell to the income tax department what money they have earned. How do they earn the money? What business are these in? Nothing. Political parties don't do any business. They get their money from donations. Okay, so they have to disclose their income. They have to file the income tax return with the income tax department, and about their expenses, they have to file their expense statement with the Election Commission of India. In case a party fails to file this expense statement, ECI can suspend the recognition of the party. Okay, like in 2015, Election Commission suspended the recognition of National People's Party. It is another thing that in 2019, this same party NPP became the 8th national party in India. Okay, what do you mean by recognition? Okay, see, recognition simply means that either a party is recognized as a national party or as a state party. Okay, registering with Election Commission is another thing. If you have formed a political party, you want to fight some elections, then you have to register your party with the Election Commission of India and you will get some benefit. That is registration. But once you fight the elections and you get some amount of votes and seats, you fulfill some criteria, then you will be recognized as either a state party or as a national party. And one thing for prelims, very important, that political parties cannot receive foreign contributions. See, Representation of People's Act 1951 Section 29B clearly says that political parties cannot receive foreign funds. Okay. However, and there's another law as well, FCRA 2010. Okay, that also says that political parties cannot receive foreign funding. However, in 2018, government amended this FCRA Act. The amendment was such that political parties can now easily receive foreign fund. See, the concept here is simply that you are a political party in India. Okay, this is India. from foreign, you cannot receive foreign any funding. Okay, the law is very clear on this. Now government in 2018 amended this FCRA. In this amendment, government changed some definitions, that which is a foreign company. When will you call a company as a foreign company? The effect of such amendment is that these foreign companies are giving lots of money to their subsidiary in India, and then this subsidiary is purchasing electoral bonds and giving to the political parties. So foreign funding is very easily coming to political parties. That is a practical aspect. But for prelims, remember this: political parties cannot receive foreign funds. Fine. What is the limit on candidates' expense? So this limit varies with the state. Okay, in some states the candidate will have can spend up to let's say 70 lakh rupees for Lok Sabha election. Okay, in some smaller states the limit is 54 lakh. Okay, so you don't have to remember the limit, just remember the approximate figure, like 70 lakh, 54 lakh for the state assembly elections. In some states the limit is 28 lakh, in some 20 lakhs, right? So don't remember this limit. UPSC can confuse you by simply saying that the expenditure limit is 2 crore or 3 crore. So that's a big figure. Just remember it's in lakhs. This particular list, that for which state what is the limit, that limit is given in the election rules 1961, conduct of election rules 1961, and it can be easily changed by the government as well. Like recently government said that due to COVID there will be extra expenditure by the parties for their rallies, so let's increase the limit. So government has increased this limit by 10%. So for prelims, just remember that it is the conduct of election rules 1961 which spell out the limit, that in which state a candidate can expend how much money, and there is no limit on the political parties. Star campaigner. So right now there was this campaigning for West Bengal elections, right? So their central leaders like Modi ji, Amit Shah ji, these people were campaigning, but they are not fighting the election. They are not a candidate to become MLA anywhere, right? Still they are going to do the campaigning. So these are star campaigners. Okay, so RPA 1951 mentions star campaigners as leaders of political party, and it says that a registered and recognized party. I just explained to you what is the meaning of registered and recognized, and registered and unrecognized. So registered and unrecognized would be, suppose you make a party right now, you form a party and you register it with election commission, but you have not won enough seats to be recognized as a state party, so you will be unrecognized but registered. So you can have up to 20 star campaigners, and recognized party can have to 40 star campaigners. The limit has been temporarily changed due to COVID, that you don't have to remember. Once the election notification comes, within 7 days parties have to inform the election commission that who all are going to be our star campaigners. Why do they have to tell this? Because when the star campaigners goes to a constituency to campaign, the expenses are not added. The expenses are not added to the candidate's limit of that constituency. Right now, in some situation, such expenses can be added, but such small situations are not relevant for your prelims exam, so ignore them. Right now, can a candidate be a star campaigner? Yes, of course. Like in 2014 and 2019 elections, Modi ji was fighting from, he himself was fighting elections from Varanasi, but he was also a star campaigner going all over India to campaign for BJP, right? So a candidate can also be a star campaigner. Model Code of Conduct. Model Code of Conduct is neither mentioned in the constitution nor in the law. Okay, more MCC is actually a guidelines that is issued by election commission after consulting with the consensus of the political parties. Okay, now UPSC can ask in prelims that what is the time duration of MCC? When does MCC come into effect? So the moment election commission announces the election dates, that moment by itself MCC comes into being. Okay, and when does it end? So it ends when the results are declared. So UPSC can confuse you. It can say that once the voting is completed, MCC goes away. No, not like that. Okay. Now, why are we reading this MCC? Because one of the arguments in favor of simultaneous election is that there is frequent imposition of MCC. When MCC is in play, then at that time government cannot announce new schemes, new development projects, right? There are so many restrictions. So political parties, especially the BJP, is saying that since there are frequent elections, after every 6 months you see there is some election. That means after every 6 months there is some MCC. When there is MCC again and again, then we can't announce new schemes. Development gets hampered. Right, so here UPSC can test you this fact that where does MCC apply? When there are state assembly election, then MCC applies only in that state, not throughout India. So the argument that after every 6 months there is MCC, so we can't do any development, is a flawed statement. Why? Because all over India there may be election after every 6 months, but if you are living in Delhi, then MCC will apply only during Lok Sabha election and when elections are there for Delhi government. Okay, when West Bengal elections are happening and MCC is applicable in West Bengal, during that time MCC is not applicable to Delhi. Okay, so in Delhi MCC will be applicable only, let us say, 2 times in 5 years. Right, so the argument that after every 6 months MCC is there, that is true for all over India, that in some part of India there is some MCC, but at a given place, and at a given place it is only twice in 5 years approximately, of course. Now what is this C-Vigil mobile app? So Election Commission launched this app that if the general public notices any violation of MCC, they can report it on this mobile app. For the first time in India, MCC was applied during the 1960 Kerala elections. Now in prelims, UPSC can ask that which of the following are considered as violation of MCC. The list is quite long. I have noted down here things which can be asked in prelims. Okay. So the minister cannot combine his official visit with an election work. So this is West Bengal. Okay, this is Delhi. In West Bengal elections, many union ministers went there for campaigning. Right, now when they go there for campaigning, obviously the expenditure is incurred in their travel and so many things. Now travel, stay and other things. Now what politicians usually do is, the minister will say that I have certain meeting in some area in West Bengal. Okay, so now he can go there, he can visit West Bengal on government expenditure because he's a minister, but he will go there, attend 10 minutes meeting, and rest for 2 days he will do the campaigning, then he will return to Delhi. So on taxpayers' money he would be financing his expenditure. So this is wrong. Okay, you can't combine these things. But in 2014, Election Commission exempted the Prime Minister from this thing. Okay, so Prime Minister can do such thing. He is allowed since October 2014. Use of official machinery for election. Suppose you are the Prime Minister and tomorrow you have a rally in West Bengal. So you tell your secretaries and other government officials that please make a list of things, election related things that I will say tomorrow in the election rally, the problems of West Bengal people and everything. So that official can say, no sir, that is not my work. It is going to be a political rally, so your speech I am not going to frame. Okay, so in case the Prime Minister or anyone uses the official machinery, officers for their election campaigns, then that is not allowed. In fact, that was the reason why Indira Gandhi was disqualified by Allahabad High Court in 1975, and few days later she imposed emergency. Now important thing is, one thing I want to mention here, that MCC, there is no legal backing for MCC. MCC is neither mentioned in constitution nor law. So what if a person like Indira Gandhi did this thing, she violated this thing, right? So can she be disqualified for violating MCC? No, she cannot be disqualified as such, because there is no statutory backing to it. The thing is that some offenses of MCC are also an offense under some other law, like under Indian Penal Code or under RPA. So what Indira Gandhi was disqualified, that was actually a corrupt practice under RPA 1951, and it was also a violation of MCC. Fine. Government can't give government ads that, see, in the last 5 years we have achieved so much. For those ad, taxpayers' money is being used, but you are using it for your own victory, so that is not allowed. You can't use caste and communal feelings to secure votes. You can't announce new government schemes or projects, and you can't transfer election related officers. Okay, so one thing is that Election Commission can relax the MCC in case there is some natural calamity or anything like that. Election Commission can say that, okay, government can announce new schemes or give monetary relief to people or such things, right? So in such, it is according to the discretion of Election Commission. Very important thing, the term of Lok Sabha and state legislative assemblies. Like in 2004, UPSC asked, one of the options was that what if Lok Sabha completes 5-year term and the president does not dissolve the Lok Sabha, what will happen? The answer is that Lok Sabha will automatically get dissolved even if the president has not notified. Okay, because Lok Sabha has a 5-year term, and this is written in the Constitution, Article 83. Similarly, legislative assemblies of state have a 5-year term as per written in Article 172. Now on page 13, we already studied that who summons or prorogues or dissolves the houses. The answer is the president or the governor, okay, as given in these articles. So what is the difference between these three things? That we have already discussed on page number 13. Now during simultaneous elections, one biggest concern is that, suppose in 2014 you had elections, okay, for center and state, all the states simultaneously. Now for 5 years no elections, after 5 years you will have some election, but in between, let us say in 2016, after 2 years, some state government falls down. Madhya Pradesh government, there was government of Congress and BJP purchased the MLAs, and now the government has fallen. Then what will happen? The synchronization will break. So there are two solutions to this problem. Okay, one thing is that when a state government, or in fact central government, falls down after 2 years, then another party forms the government, like happened in Madhya Pradesh, because the MLAs switched sides. So another the party formed the government. Okay, so that is one possibility. Now again, many things will be at play. Anti-defection law will be at play. Okay, now that will depend how many MLAs have switched the side, whether the speaker takes a decision or not takes a decision. So many other things are there. But yes, technically, two things can happen. Either another party will form the government, or there will be re-elections. In case there is a re-election, then the term of the new assembly will only be 3 years and not 5 years. Okay, that is one of the solutions. So for these things you have to amend the constitution, because in constitution it is written that there is 5-year term for state assemblies. Fine. One big difference between RPA 1950 and RPA 1951. See, there are a lot of differences. For prelims you can't remember everything, so just you have to remember that the 1950 Act is mostly about the voters. Okay, who is qualified to be a voter? How do we prepare the electoral rolls? Electoral roll is a list of citizens eligible to vote, who can vote, who cannot vote. Okay, that is a list of electoral roll. 1951 Act is mostly about the MP or the MLA. It is about the voters, it is about the MP or MLAs, and the registration of political parties. Right? So whatever option UPSC frames, just remember this fact and take a guess in the paper. The minimum age for voting is 18 years, you all know. Just remember that by which amendment act we got this 18 years. We got this 18 years by the 61st Constitution Amendment Act 1988. This amendment amended Article 326. In Article 326, it was written that the minimum age for voting is 21 years. But then it was reduced by this amendment to 18 years. Now the question can come that in a state, how many electoral rolls are there? Electoral rolls. In some states there are 2 electoral rolls, in some there is single. What is the reason? See, Lok Sabha and state assembly elections, those are conducted by the Election Commission of India, which prepares a electoral roll. But election to local bodies is conducted by the state election commissions, which are a separate body. Okay, state election commissions are not junior officers or are not subsidiary of ECI. Okay, these are separate constitutional body. Now in some these SECs, state election commission, are regulated, controlled or governed by the state laws. Okay, so the SEC of Andhra is governed by separate law as compared to SEC of Rajasthan. Okay, these are 2 different SECs. They are governed by 2 different laws, whatever their state government has made. In some states, the law allows SEC to use the same voter list that ECI is using. In some states, it is not allowed. So their SEC prepares its own list. Okay, so some states have a single list, voter list, and some have 2 voter lists. One more thing, these voter list electoral rolls are periodically revised. Why is a revision needed at all? Because RPA says who is qualified to be a voter? A person who is an ordinary resident of that constituency. Suppose this is India and you are from, let us say, Madhya Pradesh. Now when you passed your 12th class, you went to Delhi to study, and since then you are in Delhi. Your parents, family, everyone is in Madhya Pradesh. Periodically you go to Madhya Pradesh, but you are, for the last 5 or 6 years, you are in Delhi itself, studying or doing job or whatever, something like that. Take care. So now you cannot vote in Madhya Pradesh because you are no longer a ordinary resident there. Okay, so therefore you will have to, your name will be struck down from this list. So these electoral rolls have to be periodically revised. Now democracy and accountability. One concern, what are we reading? We are reading simultaneous election, right? Whatever UPSC can frame, how questions UPSC can frame. Now democracy and accountability. One concern with simultaneous election is that it will reduce government's accountability towards the people. Okay, democracy does not mean that government is formed by the people. Democracy is not just this. Democracy also means that government is accountable to the people. We elect the government, but after election there are few other elections as well. There is some right to recall in some places. Okay, these are some ways in which we ensure accountability of the government. For example, in 2014 we elected BJP. Now in 2019 we again elected BJP. But the elections in between, did BJP form the government everywhere in all states? No. In some states, maybe central government took some steps which annoyed the local people. So in a way to punish the central government, people will not vote for BJP. People will vote for some other political party. Okay. So frequent elections are a way to ensure accountability from the government. Right. Now there are some other tools also to ensure accountability. People can meet their MP or MLA, visit their office, right? People can voice their concern over media, over social media. But to be very practical, accountability is ensured only through elections. Why am I saying such a thing? Because for politicians, there is just one thing that matters. that whose government is formed. When they feel that they won't be able to form the government next time, then they will act according to your wish. Else, they will do whatever they want. Okay. Now look at this Indian Express. This is from the interview of a union minister published in Indian Express on 16th of March. It says the context here is the farmers' protest. The minister was asked that what has been the impact of farmer protest on the BJP. The minister simply says, he clearly says, there has been some impact, but we are not concerned. Why? Because there is lot of time for election. ठीक है ना? He is simply saying that this farm laws are going to impact Haryana and Punjab. The APMCs there may be destroyed, I don't care. That is what he's saying. But if you understand the context, what he's saying is that APMC system is strong in Haryana and Punjab. They will be affected. But in Western Uttar Pradesh, APMC system is not well developed. So people here won't be affected. People of Western UP are protesting just as a sympathy. They are getting emotional and protesting. However, I have enough time before the next election. ठीक है ना? So I know how to win the election. We will win. So I don't have any such worry. So politicians understand only the language of elections and nothing else. So the thing is that when there are frequent elections, you are getting accountability from the government. Problem is you can't fool all the people all the time, right? So the solution is simple, that you don't conduct elections. Okay, conducting election should not be the aim of democracy. ठीक है? So you conduct election in 2014 and in 2019. If you still don't understand the gravity of the situation, think like this, that you are in an abusive relationship, right? And your partner knows this, the partner abuses you. You can't get out of that relationship, you can't walk out, because for the simple reason that there is a 5-year contract. Before 5 years you can't end the relationship. You will suffer silently, and your abuser will continue to abuse you through making any laws or whatever thing, because he is assured that after 5 years when we have to renew the contract, I know what is his or her sentimental point. I will exploit that sentimental point, talk in a very emotional way, and I will renew the contract, and 5 years whatever I want I can do. Okay, see this 2017 question. Democracy's superior virtue lies in the fact that it calls into activity. Democracy calls into activity what? It is the ordinary men and women, their intelligence and their character. Democracy is not about getting a superman kind of you get a very strong government, or you get a very able or visionary leader. Okay, or you proudly say that our country has world's biggest democratic party. No, these are not the characteristics of a democracy. The characteristic of a democracy is that the ordinary men and women should be intelligent enough to understand what political parties are doing, and ordinary men and women should have a strong character. They cannot be flown away by sentimental things on caste, communalism, and they should not be divided on such things. Okay, that was the previous year question. Now look at this NCRT class 12. Okay, NCRT class 12, Politics in India Since Independence, chapter 2. It has a quote from Dr. B.R. Ambedkar, which he gave in the Constituent Assembly. It says that hero worship is a dangerous thing. In India, hero worship plays very important part, but hero worship is a sure road to dictatorship. Today you are very happy that we have a very strong leader. We are so lucky to have such a strong leader among us, but it will definitely lead to dictatorship. That is what Ambedkar warned us 70 years ago. Now when we have simultaneous elections, and we also have in India a very popular party or leader, what will be the result? The result will be one party dominance. It simply means that in the center and majority of states, not all, but in majority of states, single party will dominate. Now think for a moment. If a single party is dominating in Lok Sabha and majority of states, what will happen? Within a few years, that party will also dominate the Rajya Sabha. because Rajya Sabha members are elected by the MLAs, and maximum MLAs are of the same party that is in Lok Sabha as well. Now once you get MPs and MLAs everywhere your own party, you can do anything to the constitution that you want, and we know how strong Supreme Court is nowadays, pun intended. So example was the Congress of 1947-67. There were simultaneous elections in India. No accountability for the 5 years in between. Hence, party can do whatever they want, and we know the consequences. What happened in 1970s and 1975, right? Now see, even in 2017, UPSC asked this question in mains. Although this is not relevant for prelims, but still UPSC can twist things, ask the concepts. Simultaneous election to Lok Sabha and state assemblies will limit the amount of time and money spent in electioneering. Very good thing. But it will reduce government's accountability to the people. Right? Nowadays in prelims, UPSC is asking many conceptual things like this question. Polity is not just about fact. Okay, it is also about these concepts. Therefore, such analysis was very much required, and you should also look at previous year questions. Right to recall. So recently Haryana has brought this Panchayati Raj Amendment Act 2020. It gives the people there the right to recall their local representatives. The condition is such that to initiate the proceedings, 50% of Gram Sabha members should sign, and for recalling the representative there should be 2/3 majority. Okay, so it will ensure accountability, no doubt. Okay, now the concern can be that it will bring instability. Okay, now what you have to remember for prelims is that Haryana is not the first state to have right to recall. Already many states in our country like Madhya Pradesh, Rajasthan, Bihar, okay, Chhattisgarh, so many states have this right to recall in some form or the other, but that is for their local representatives, panchayats or municipalities. That is not for MPs and MLAs. Now, right to recall simply means that before the term expires, you are calling back your elected representative. It will increase accountability, but it will bring instability. Now, right to recall is an instrument of direct democracy. See, direct democracy simply means these are people, and people are voting on some issue that either we want this thing or we don't want this thing. That is direct democracy. So people are voting whether we want this person or we want this person to be removed. Representative democracy. Okay, in representative democracy, people elect the representatives and representatives take the decisions. We elect our MPs, MLAs. Okay, these are MP, MLAs, and they take the decision in the parliament. Okay, so question, maybe UPSC may not frame question on these things, right to recall, but UPSC may frame a question on direct and representative democracy. What is the basic difference between the two? Okay, India follows representative democracy, but Gram Sabha is a fine example of direct democracy in India. Okay, what about panchayats? Panchayats are representative democracy. Panchayats are not direct democracy. In panchayat, you choose a person to be a member of panchayat, right? And that to three levels. So again, there you are choosing the representative. That is also representative. But Gram Sabha takes its decisions itself. Therefore, Gram Sabha is direct democracy, not the panchayat. There are some other instruments of direct democracy, like initiative, referendum, or plebiscite. In initiative, people initiate a new law. People say that we want such a law. In referendum, a particular bill is referred to the people. Okay, this is a bill and government refers the bill to the people, and people vote that yes, whether this bill be passed, ayes or noes, like happens in Lok Sabha. Okay, in plebiscite, you get an opinion of the people. Generally, plebiscite is for whether we want independence, whether we should remain with this country or not, for such things. Okay, now one very important thing you have to note for your prelims is that none of these things are binding on the government. Okay, some coaching institutes say that referendum or plebiscite or something like that is binding and the other is not binding. That is totally false. Why do coaching institutes say such thing? Because in Australia referendum is binding on the government. Okay, and it can be used to amend the constitution also. The law there is such that, okay, but that is not true for everywhere, na? That is not true for India, that is not true for USA, right? So please don't get confused. For example, please remember none of these things are binding. Government may announce prior that yes, whatever be the result of the referendum, we will follow that. That is a separate issue, right? Also, media nowadays uses the word referendum mostly wherever recently in the recent past plebiscite happened in few countries, but media nowadays does not use the word plebiscite. Plebiscite word has a certain negative connotation. It looks as if people were being exploited by some foreign country, and people, there is a plebiscite, people are fighting for their independence and such things. Therefore media nowadays uses the word referendum. For prelims, maybe UPSC can frame a question that you have to match the following where the independence referendum happened. So Scotland's independence referendum of I don't know if it is 2014 or 2015. I think it is 2015. Anyways, so Scotland's independence referendum was against UK, Catalonia's was against Spain, and New Caledonia was from France. For prelims again, just remember the combination: Scotland, UK, Catalonia, Spain, New Caledonia, France. Where is this New Caledonia? So this is your Australia, this is, let's say, New Zealand. So here is a small island of New Caledonia. Okay, it voted in everything, in all these three things. The final result was that they should stay in respective countries only. I think this Catalonia referendum was declared illegal by the Spanish Supreme Court. Anyways, in Scotland and New Caledonia, people voted that they want to continue being under the another country. Now let us see, the news was about the Panchayati Raj, right to recall in panchayats. Let us see a previous year question. In 2015, UPSC asked, what is a fundamental objective of Panchayati Raj system? Fundamental objective. Okay. Now, if you go by the official answer key, the answer was 1 and 3. 1 is people's participation in development, right? And third is democratic decentralization. Panchayati Raj institutions' aim is not political accountability. The aim is not financial mobilization. Okay, getting accountability is not by forming the Panchayat Raj institution. The main aim here is democratic decentralization. In 2017, again, see the question: local self-government can be best explained as an exercise in democratic decentralization. Some students were confused. They thought the answer would be direct democracy. No. Local self-government means panchayats in rural areas, municipalities in urban areas. Panchayats and municipalities are not direct democracy. Direct democracy is Gram Sabha, right? So if you would have learned this 2015 answer key that democratic centralization is the aim, you would have directly marked this democratic decentralization. Fine. Now what is the meaning of this democratic decentralization, and what would be democratic centralization? See, India is a huge country, right? There is a small village. It will have its local issues. There is some village here, some village in north, some village in south. These villages have their different local issues, and these local issues change from time to time, right? Now, in the local panchayat or municipality election, if central government ministers come again and again, because they're very popular leaders, right? In the TV, whom do we see? In the TV, throughout the day, news is filled with union ministers, how good the union ministers are. You know? Now, when those union ministers come to campaign for elections to panchayats and municipalities, obviously people get swayed. People think, wow, we will vote for this political party itself. Problem is that these people, these ministers came here to get the votes, but they don't know the local problems. And tomorrow, when the local problem is there, this minister will not be concerned, because there are thousands and lakhs of such villages. Can a central minister look after everything? No, of course not. Therefore, there's a concept of democratic. There should be democracy, but the democracy should be decentralized. You cannot say that we as a country, because this is often said in the news, that we as a country have elected a central government. Now this central government is empowered to do anything and everything. No, you can't say like this. That would be democratic centralization. You have centralized everything. Here our aim through Panchayati Raj institution is that democracy should be local. Local problems, local solution. Democratic decentralization and people's participation in development. Fine. Voting rights. So before these assembly elections, there was this news that NRIs may soon get postal voting rights. Okay, this is another news why NRIs won't be able to vote in these elections. Actually, they can. Okay, this statement, this heading is a bit misleading. So if in prelims question comes, can NRIs vote? Yes, they can. Okay, so this is a bit misleading thing. NRIs can actually vote since 2011. In 2011, RPA 1950 was amended to allow NRIs to vote. Now again, which RPA should have been amended? 1950 or 51? 50, of course 50, because 50 is about voters and 51 is about MPs and MLAs, the candidates. NRIs have to register themselves as overseas voter. They have to show the passport and then they can vote in the constituency. Which constituency? That is mentioned in their passport address. See, in your passport there is some address mentioned, no? So according to that address, wherever is your polling booth, okay, you have to register for that only. You have to show your passport and then you can vote. That is a procedure. Now UPSC can confuse you. UPSC can say that NRIs can vote as overseas voter. For that they have to register with the Election Commission. Yes, they have to register. Once they have registered, they can vote from anywhere in India. In India they can come and vote anywhere. No, not like that. Okay, whatever address is given in the passport, only there they have to vote. Problem here is, to vote they have to come to India. They have to be physically present here. Therefore, government wanted to give them some rights like postal voting rights. Government said either we will give them proxy voting right or we will give them postal ballot right. Okay. Now, what are these things? Proxy voting. Suppose you don't go to your college, right? And you tell your friend that please put my proxy. Then your friend will put her attendance as well as your attendance, right? So the friend will be casting two votes, one for herself and one for you. That is proxy voting. Okay, this is available. Who can use this proxy voting thing? It is available only to service voters. Service voter means members of the armed forces. Armed forces like armed forces, basically here the concept is that to any organization to which Army Act 1950 to any organization to which Army Act 1950 applies, members of that force are called as service voter. They can use this proxy voting method. For example, CISF, CRPF, BSF, ITBP, Sashastra Seema Bal, these. Okay. Also, if there is any government employee outside India, like diplomats, tomorrow you will become IFS officer, you will be posted in some other country. Okay, you are government employee posted outside India, so yes, you can vote, you can use this proxy voting method to cast your vote. And armed police force of a state while they are serving outside that state. Okay. What is postal ballot? Postal ballot are also called now as ETBP, or electronically transmitted postal ballot paper. Here, Election Commission through internet sends the postal ballot to the voter, and voter casts his vote and sends it back to the Election Commission through the post. Who can use this facility of postal ballot? The service voters and those who are in preventive detention. Right? So this thing you have to remember. Now you can get confused. See, service voters have both the facilities. What you can get confused is about people who are in preventive detention. So just remember the old fashioned way, that there is a jail, okay, a house arrest kind of thing. Okay, in that house arrest or preventive detention, whatever, a person is there and he can cast his vote through ballot, through this post, but he cannot call someone and say that on my behalf you cast my vote. Okay, remember like that. So now government wanted to give these rights to the NRIs. Right now they don't have these rights. If you want to give them proxy voting right, you have to amend RPA 1950. But if you want to give them postal ballot rights, then you have to just amend the Conduct of Election Rules 1961. Okay. Now RPA 1950 is about the voters, and it allows only ordinary residents to vote, like I explained earlier. Okay. So now NRIs are not residents, they are non-resident Indians. They are not resident, hence they could not vote earlier. Therefore government had to in 2011 amend this act and allow the non-resident also to vote. Can OCI vote? Overseas citizens of India. Overseas, see, NRI is registered as an overseas voter. So UPSC can confuse you. It can say कि overseas citizens of India can also vote. No, OCI are not citizens of India. Okay, overseas citizen of India is not a citizen of India. Therefore, that person cannot vote in elections in India. Previous year question of 2017. Right to vote is what kind of right? It is a constitutional right. That year many coaching institutes had some problem. Some of them said that it is a legal right. No, it is clearly given in Article 326 of the Constitution. UPSC answer key also said it is constitutional right, and NCRTs of class 9th and 11th also clearly say that our constitution makers gave each adult the right to vote. Okay, whether you are Ambani or you are a beggar on the street, it doesn't matter. The voting value of both are equal. Okay, it is your constitutional right. One important thing for prelims: if a person is in prison or in police custody, that person cannot vote. See here, okay, not the preventive detention. This is another thing. Preventive detention is another thing. But otherwise, instead of preventive detention, if for any other reason you are in the prison or in the police custody, then you cannot vote because you are not a service voter. You are not in preventive detention, so you can't use proxy voting or postal ballot. And since you are in custody, you can't go physically to the station polling booth. Therefore, you cannot vote. However, you can contest elections, provided you are not disqualified. Because I hope you know that if you are you have been sentenced for more than 2 years, then you get disqualified for the jail term and 6 years once you come out of the jail. So if you are not disqualified, then you can obviously contest the elections, but you cannot vote. This is important thing. Opinion polls or exit polls. See, most of the people are quite clear that to which political party they are going to vote. But there are substantial quantity of people, if you want to say, who are undecided. Okay, they can vote for any party. Those are called as fence sitters. Okay, what are these? Who are these fence sitters? They are sitting on the fence. It is a fence. They are sitting on it. They can go either to the BJP or to the Congress or to the Aam Aadmi or to any regional party. Okay, for them, anything, they can go anywhere. So whichever political party is able to influence them, they will win the votes, right? Whether the political party may give ticket to some Sunny Deol type person, ठीक है ना, or they will bring their star campaigners, and a small man, if he sees a big politician near him in an election rally, he will vote for that person. So that is the reason why there are tickets are given to famous film stars like Hema Malini, and campaigns are done by big leaders even for municipality polls, right? Now the thing is here, concept is here simple, that fence sitters can sway the poll. They can decide who will win the election. Now there is one human psychology, it's a matter of human psychology, that nobody wants to give vote to the party that will lose the election. You are a fence sitter, you are undecided whether I will vote for BJP or to Congress, right? And then you are watching the news, and in news the opinion polls, whatever polling they are showing, whatever they are discussing, suppose they convince you, the media house convinces you कि भाई इस साल तो this time there will be government of BJP in West Bengal, right? Then what you will do? Will you vote for Congress? Will you vote for Trinamool? No, you don't want your vote to go waste. You will definitely vote for BJP. Why? Because you know that this party is going to win. So opinion polls, exit polls, all these media polls have very big role in deciding who will actually win, right? For the same reason, the Election Commission actually tries to regulate them, okay, because they can have substantial impact on the public. Okay, so now what is the difference between the two? The difference is quite simple. Opinion poll is whom will you vote for, okay, so it is obviously conducted before the voting. Exit poll is when you exit the polling booth. When you exit the polling booth, someone will ask you ki whom did you vote for, okay. The result compiled from that survey will be called as exit poll. Whom did you vote for? That is after the voting is done. Now once these surveys are done, there is some restriction on when can the result be announced, because the announcement of the result is going to influence the fence sitters, है ना? So therefore there is some restriction. The restriction is that for opinion poll, you cannot show the result of opinion poll during silence period. What is silence period? I will just explain it to you. And exit poll only after half hour of end of all phases. Like in West Bengal, the elections were on 27th March, then 1st April, 6th April, and such like that. Okay. Now, when on 29th, the last day of the polling is 29th April, let us say evening 6 p.m. The polling will end on 29th April 6 p.m. So once this polling ends, half an hour after that, you can tell what was the result of exit poll of 27th. Okay, so media houses would have done the survey on 27th of March itself, but they will not announce the result. When people voted on 27th, they came out of their polling booth, media houses asked them the question, but they will not show the result. They will show the result only from 6:30 p.m. on 29th of April. That according to exit poll, such and such party is going to form the government. Okay. Now, is there a law for these things? For opinion poll, there is no specific mention in the law. However, for exit poll, it is clearly mentioned in RPA 1951, section 126A, and that was added in the year 2009. Right. Now, what is this silence period? Silence period is mentioned in RPA 1951. Okay, section 126(1). It says that silence period is 48 hours before the end of polling in an area. During this time, there cannot be any campaign or anything, and even media cannot show Media cannot show any election matter during this time. Please listen carefully. Election Commission does not regulate media during silence period. Election Commission does not regulate media or control media during silence period. Election Commission simply says that media should not show any election related matter during this period. Okay, it does not mean that Election Commission is controlling the media. Okay, regulation is one thing, these things, these advices and all things are one thing, but controlling is entirely different thing. Now, what is silence period in a multi-phase poll? This question can come. See, on 27th, polling is from, let us say, 7 a.m. to 6 p.m. 7 a.m. to 6 p.m. Okay. Now, what is the silence period? In the areas which are going to poll on this date, the silence period would be 48 hours before the end of polling. So 25 se pehle 26, then 25. On 25th March, evening 6 p.m. not morning 7 a.m. evening 6 p.m. your silence period will start. The silence period will start. Fine. Now, when there is, during these 2 days, there is silence period in the areas which are going to vote on 27th. But campaigning will continue in other areas which will vote on a later date. That is a silence period. Fine. Now, one very important thing, a very interesting thing that is not relevant for your prelims, that actually there is a very strong reason why these media houses conduct exit polls. See, on 27th when people voted and came out, okay, then media houses calculated that which party is going to win from these constituencies, and exit polls are very, very accurate. Results are not announced. Result will be announced on 29th. However, political parties get to know the result. Political parties, same day, they come to know about the result. What are they going to do with this? They are going to fine tune their strategy, because there's a huge gap between the next phase, है ना? So they get time to fine tune कि we campaigned for this poll for 27th, we campaigned in such and such manner, in what manner have the people voted, so we will fine tune our small strategy for the upcoming poll dates. Okay, so these exit poll results are very much useful for the political parties. Also, it helps them to start the alliance talks without waiting for the formal result. Delimitation Commission. Delimitation Commission, it is about the fixing the boundaries of Lok Sabha and state assembly constituencies. It also identifies which seats are to be reserved for ST and SC candidates. The commission is appointed by the President of India, who are the members. The chairperson is a Supreme Court judge serving or retired. Another member is the Chief Election Commissioner of India or any other election commissioner. The State Election Commission of the concerned state, for which state you are doing this activity of delimiting, of changing the boundaries, the State Election Commissioner of that state, and there are some associate members. Delimitation Commission is a very powerful body. Whatever orders it gives, that is, if the Delimitation Commission says that in a state these have to be the boundaries, constituencies, okay, then that is final. Nobody can question that. Parliament cannot change such constituencies. You cannot go to the Supreme Court and say that these constituencies have been made wrong, anything like that. Okay. Now, what is the logic? What is the purpose of delimitation exercise? Simple, that everyone should get equal vote. That what we can say is that the voting power of each individual is same to the extent possible. That is, each Lok Sabha MP, for example, should represent same number of people. However, there was a freeze. On this activity. Why? Because the population was increasing rapidly after 1947. Now, when the population is increasing, obviously, if you want that each MP should represent same number of people, So from densely populated areas, you will have more number of MPs, right? For example, you see that there are so many MPs from Bihar, so many MPs from UP, West Bengal, but from the southern states it's quite less. And that is due to this population imbalance. Therefore, in 1971, a freeze was put. In 1976, okay, in 1976, a freeze was imposed till the year 2000. Later on, this freeze was extended till 2026. However, internal adjustment to the state boundaries was allowed. That is, at 1971 level, suppose in 1971 level, Uttar Pradesh had 80 seats, okay, and Rajasthan, let us say, had suppose 20 seats. So later on, what government allowed was, government said that Uttar Pradesh will continue to have 80 seats. However, within Uttar Pradesh, some region would have more population, some would have less population. So internal adjustment will be done by the Delimitation Commission, subject to the overall 80 seats of UP. Number of seats won't change. Rajasthan will continue to have 20 seats, like that. So internal adjustment was allowed within the states. These are small amendments, like 87th amendment said that 2001 census data can be used instead of 1991 data. In 2008, the report of the latest Delimitation Commission was accepted. For prelims, you should know the purpose. What is the purpose of Delimitation Commission? For fixing the boundary of Lok Sabha and State Assembly constituencies. You should know that the chairperson is not the Chief Election Commissioner of India. Chief Election Commissioner is a member of this. Yes. Is he the chairperson? No, he is not the chairperson. Okay. UPSC can ask that how many times has the Parliament enacted the Delimitation Commission? So Parliament forms this Delimitation Commission under the Delimitation Act. Parliament passes the Delimitation Act under Article 82 of the Constitution, and on that basis, President of India appoints this commission. Right? So till now, Parliament has enacted this law, Delimitation Act, 4 times: 1952, 62, 72, that is after the census, and in the year 2002. Now in the year 2002, when Parliament enacted this act and President appointed this commission, then there was some problem in some states. In some states, this commission could not do its work properly. Okay, in majority of most of India, it completed its work by 2008, submitted the report to the government accepted the report. But in some states, the exercise could not be done due to security reasons. Therefore, now the President of India has again constituted a new Delimitation Commission under which act? Under the 2002 Act. Why? To delimit the boundaries of Jammu Kashmir and Aman states. Aman states are Assam, Manipur, Arunachal, Nagaland. Because due to security reasons, the delimitation exercise could not be done in Aman states earlier, and for J&K it was reorganized recently. Therefore, okay, what you have to remember is that in the Aman states, M stands for Manipur. M is not Meghalaya. Okay. For general knowledge purpose, the smallest Lok Sabha constituency area wise is Chandni Chowk of Delhi. Population wise, the smallest Lok Sabha constituency is Lakshadweep. Largest area wise is Ladakh, and largest population wise is Malkajgiri in Telangana. Electoral bonds. So in electoral bonds, the identity of the donor or donee is not disclosed. In fact, it is protected. Okay. In fact, earlier, due to this secrecy, Election Commission and RBI both had written to the government that this electoral bond scheme is flawed. It gives a huge scope of corruption, but government ignored such things. Now, for exam, you should know what are electoral bonds and how do they work. The working is quite simple. You are a big businessman. Congratulations. You want some favorable policy decision from the corrupt politician. Politician says, I am ready to frame the policy according as per your wish, but I cannot because I don't have the government. I need to form the government. So this rich person will say, fine, I will give you lots of money. This rich person says to the politician, I will give you lots of money. You use that money to campaign, and once you campaign with lots of money, you are able to influence public opinion and you will form the government. Once you form the government, you help me back by framing favorable policies. Now, how does this rich person give money to the politician? Okay, if today Ambani ji, respectable Ambani ji, decides to give 1000 crore rupees to BJP, then somehow maybe few people will say that this is wrong, he should not be doing this, because then government will frame telecom policies in favor of Jio only. That Jio will suddenly gain the market share and Airtel Vodafone will go down. So someone will say that such a thing. So the solution is that Ambani ji will go to SBI, only SBI, no other bank. Okay, Ambani ji will go to SBI and he will give check or NEFT or whatever to SBI. SBI in return will give a piece of paper to Ambani ji. This piece of paper is electoral bond. This electoral bond, Ambani ji, he will hand over this to the politician. Politician will hand over this electoral bond to SBI, only SBI, and SBI will give that money into Netaji's bank account. Okay, during this transaction, this electoral bond does not bear the name of Ambani or the political party. Nowhere. Okay, that means electoral bonds are bearer bonds. These are bearer instrument. That means they are issued only in the physical form. There is no ownership info. Take out your wallet. Your wallet has a 100 rupee note. Does it have your name? No. The 100 rupee note is a bearer instrument. It is in physical form, and whoever holds this in their hand, it is his. Nobody's name is written on that. So that is bearer instrument. There is complete anonymity. Okay, electoral bonds, this scheme was introduced by the Finance Act 2017. The purpose is to make anonymous donation to political parties. It is available in denominations from 1000 rupees to 1 crore in multiple of 10. It is not available throughout the year. It is available only for 10 days after 3 months interval in these months or as specified by the government. Like there is an election, West Bengal election or anything like that. So before that, government will notify the dates that during these dates electoral bonds can be purchased from the SBI. Okay, it can be purchased only through specified branches of SBI and it is valid only for 15 days. When Ambani ji got the bond from SBI, then within 15 days Netaji has to encash it from SBI. Otherwise that money will go to Prime Minister's Relief Fund. Who can buy electoral bond? I mean, who can be this Ambani? Any Indian citizen or NRI or Indian company, but not overseas citizen of India or foreign national or foreign company. However, like I told you earlier, foreign companies are purchasing electoral bond, not directly, but through their Indian subsidiaries. Who can get funds by electoral bonds? You have to register your political party under RP 1951, right? And you should have got at least 1% votes in the last Lok Sabha or State Assembly elections. What difference has this Finance Act 2017 brought? Earlier, political parties had to tell that if a political party got funds more than 20,000 rupees, then they had to tell कि from where did I get this money. Now they don't have to tell. Okay. Earlier there was a limit that if Ambaniji's company Reliance makes a profit of, let's say, 100 crores in a year, then at maximum he can donate to Netaji only 7.5 crore rupees. That was a restriction earlier. Now there is no restriction. Even if he is making a loss, suppose he is not Mukesh, he is Anil Ambani, and his companies are making a loss, even then he will give money to the Netaji so that he can get favorable deals and policies. Take. So earlier there was 7.5% limit. Now there is no limit. Even loss making companies can donate as much money that they want. Earlier companies shareholder knew to which party their company was donating. Now they don't know. You are holding shares of Reliance, but you don't know how much Reliance is giving to which political party. Right? In brief, when the amount is small, then earlier there was no problem up to 20,000 rupees. Now it is 2,000. Okay? So up to 2,000 rupees a political party gets a donation, there is no problem. But when we are talking about the big amount, earlier the law said that you must disclose the identity of the donor. Once you get money more than 20,000 rupees from a person, you have to tell who is that rich person who has given you more than 20,000 rupees. You must disclose. Now the law says you must protect his identity. Unfortunately, that is how things are. Right to information. RTI Act 2005. See, why is RTI needed? Or how can information expose corruption? See, before 2005, the situation is that you are a citizen, you paid tax to the central government. Government wants, you see, why are you paying tax? Because you want some roads to be constructed, right? You want some facilities as well. So central government sent the money to your, suppose let us say collector. Suppose, take a bureaucrat. Now bureaucrat says fine, we will get the road made. The bureaucrat gives the tender to some contractor that you construct this road. Now what happens is that this contractor is no one but actually the junior brother of Netaji. Netaji or contractor is one and the same thing. That is how actually most Netajis get their money from. Anyways, so now your taxpayers' money to make the road has gone through the bureaucrat to the contractor. Contractor uses third class quality material, makes the road, and he gives money saved to the Netaji. Okay, that is how things get. Now what RTI did was, through RTI you can get this, once you get this road tested, that what kind of material was used in this road, when was this road made, was it made only on the papers or physically also there is a road. So by asking such simple questions you can actually expose corruption, right? So you file an RTI with a bureaucrat that, sir, according to your papers, according to the government files, when was this road made, what quality of material was used in this road, and such things. Then you go to an independent organization, get the testing done, and then you show that the two reports are quite different. That means there was some corruption, right? Now when this bureaucrat, okay, when he wants to hide his corruption, what he will do is he will not disclose the information, or he will, in reply to RTI, he will give you some wrong information, or he will deny the information. He will say no, I cannot answer such a question, है ना? Because otherwise मंत्री जी मारेंगे and मेरा commission चला जाएगा and such things. So what used to happen is a citizen used to appeal to the Central Information Commission. Central Information Commission is a statutory body under RTI Act, a very powerful body. These CICs were very, not now, but earlier they were very senior members. When these very senior members used to tell a bureaucrat, why the hell are you not giving this person information? How dare you give him wrong information? Okay? So these bureaucrats had to comply with the orders of CIC. Okay, so see, the fact thing about government is that if there are two government employees and they both are at the same pay level, same grade, they won't listen to each other. But once there is a very senior person a government employee, he says anything to this government employee, he has to listen. That is how practically things are. Okay? Now, after this Amendment Act of 2019, the thing is that the stature of the CIC has been reduced as an ordinary bureaucrat. Now these ordinary bureaucrats are, this CIC has been degraded so much, he can be easily influenced by the politicians and the bureaucrat won't be listening to him. Right? Therefore, this your appeal and everything, all these things won't matter. So that is the crux. For exam, you should know what is the changes with this law by this 2019 amendment. Earlier, these CICs, they had fixed 5-year term. Now the central government will notify that if I am appointing you, then how much time you will have. The salary equivalence, the CICs and ICs at the central government, they were almost equivalent to the chief election commissioner and election commissioners. Right? Election commissioners are very powerful people, very senior people. Earlier they had similar salaries, so their stature, the stature of CIC was equivalent to CEC of India. That is why people used to listen to him. Now it is the central government that will determine. Interesting thing is, even for state election commissions, it is the central government that will determine. Right? The terms and condition of the service, earlier the terms and condition of their service was protected by the law. The terms and condition of his service was protected by the law. Okay, not at the whims and fancies of the politician, but now his terms and condition are at the whims and fancies of the politician, not protected by law. Fine. So the basics of RTI Act: the applicant need not give the reason why you have filed the RTI. No, not necessary to give the reason. It applies to all public authorities. It puts some time limit. Okay, when you file an RTI, you will get a result, you will get a reply within 30 days, or if it is a matter of life and liberty, then you will get a reply within 48 hours. Okay. The first appeal. Okay, just a minute. So you filed an RTI with this bureaucrat, he didn't reply, or you're not satisfied with his reply, so you make an appeal. You make an appeal to his senior. Okay, if you're not satisfied with his answer, you can go to the CIC if you are talking about the central government employees. However, if you're talking about the state government employees, then you go to the state information commissioner. Okay, remember one thing, if you are going to the state information commission, then you can't say that I'm not satisfied with the order of state information commission and therefore I will approach the CIC in the center. No, that is not thing. Okay, these are some state, suppose this is state government, this is central government. Okay, you have a problem with their RTI, you go to the state information commissioner. You have a problem with central government's reply, you go to the central information commissioner. Okay, these are two different things. You can't say that in appeal to SIC I will go to CIC. No such thing is there. So the final appeal lies with the CIC for center and SIC for the state, and some information can be exempted under section 8 and 9. Now, which is a public authority under this act? So first of all, it is a section 2H of RTI Act which defines a public authority. What is a public authority? If any body, it is a constitutional body like Supreme Court, Election Commission of India, CAG, UPSC, these are constitutional bodies. So yes, under RTI Act, these are public authority. If government framed a law to make a body like NHRC, National Human Rights Commission, then that is also public authority. If government issued a notification to make a body like Niti Aayog, that is also public authority. Okay, or if any body is owned or controlled by the government, that is also a public authority like PSU. Okay, government companies are public authority. Or any NGO that gets that gets substantial money from the government, like DAV Trust, that is also a public authority. Okay, so the recently in news, there were three things that were in news about public authority. Office of Chief Justice of India, Supreme Court has said yes, it is a public authority. Office of Attorney General, I am sorry, I think this Office of Attorney General is not a public authority. Okay, here a cross has to come. Yeah, so please remember that Office of Attorney General is not a public authority. Okay, PM Cares is not a public authority. You can't file RTI for PM Cares. Although last year in PT 365 I had explained how PM Cares meets these criteria clearly, absolutely clearly, but still anyways the official position is no, RTI is not applicable. Similarly for Attorney General, no, RTI not applicable. For CJI, yes. Okay, so one more thing, UPSC can frame a sentence that what if a person has filed an RTI and for some reason when the application is still pending, the person dies for any reason. Then in that case what happens? The RTI application stops automatically. The answer will be no. Okay. Actually through in 2017 government was inserting some draft rules. In that government has put this provision that if you file an RTI and you die for any reason, the application will automatically end. But then there were protests and this thing was not included. Remember this thing. Then there are some sections, important sections of RTI that are often in news. For prelims you don't have to remember these section numbers. Okay, these numbers you don't have to remember for prelims. Why I have written it here is UPSC can frame sentences from these statements. Okay, so UPSC can say that public authority is not defined in the act. Of course it is defined, right? Then the act also says that public authorities have to provide some information themselves. They don't have to. There are certain information for which the public authority should not be waiting that someone will file an RTI. Okay, some information, there is some kind of information which they should automatically by themselves provide. Okay, they should put on their website most of information so that there are less RTI applications, right? Some exemptions, that is in which cases RTI is not applicable, that is given in section 8. It also says that personal information should not be disclosed. However, personal information can be disclosed if public interest is served, right? Suppose there is a very high ranking official, okay, and that person, it is alleged that that person has amassed a lot of wealth. Okay, then that person will see that how much wealth I have or how much wealth my spouse has, that is my personal information, I should not disclose it. But if that is a substantial amount of money, take na, and there are allegation that it was through corruption, then yes, it should be disclosed because then larger public interest will be served, right? The act also clearly says, RTI Act also clearly says that information protected under Official Secrets Act can be disclosed if public interest is higher. If there is substantial public interest, then even official secrets can be disclosed. Okay, so these sentences are important for your prelims. Consumer Protection Act 2019. So it's a pretty simple thing. Okay, there are some rights of consumer, like think you are going to buy a car. Okay, so you should be aware what all type of cars are available: hatchback, sedan, compact SUV and everything. Okay, whatever kind of car it is, it should be safe. Okay, no car should be such that it is hazardous, you ignite it and you turn on the ignition and the whole car burns. No. Okay, the car should not be hazardous. Then it should be of what quality it is. Okay, you should know about the build quality, about the certifications that the car has obtained from the government. You should have the right to explore the choices, what are the competitors offering. Then if there is some problem, the company should have a mechanism to hear you, and if the company is not listening to you, then you should have the right to complain against the company at suitable forum, Okay, these are some basic consumer rights. For exam, you just have to use your common sense. Look at the previous year question of 2012 about the consumer rights. First statement is, consumers are empowered to take samples for food testing. Correct? Common sense says yes. If you think something is wrong with some food item, you can take it for testing. No fees is required. If you file a complaint in any consumer forum, then no fees is required. This is wrong. I mean, suppose you are suing a company for like 50 lakh rupees or 1 crore rupees. If you are suing a company, then you are not a small person, right? You would be a big person. The company would be a big entity. Then obviously, why would the courts do it for free, right? So the consumer courts also charge some fee. So the second statement is wrong. Third, in case there is death of consumer, the legal heir can file a complaint on his behalf. Obviously, a person who has died cannot file the complaint for himself, na? So yes. So use your common sense, you should get the answers. 1 and 3 are correct. Now in 2019, government amended this Act 1986 Act. So there are some changes. Just let us see those changes. So earlier there was no central regulator. Now there is central regulator by the name Central Consumer Protection Authority. Place of filing the complaint. Okay, earlier you would it was, suppose you are living in city this and the person who provided you the service is in city this, so you had to earlier file a complaint in this person's city. Now this is not required. You can file the complaint in your own city, right? The limits have been increased. So consumer forums are at 3 levels: district level, state level, national level. So district level forum can entertain complaints with values up to rupees 1 crore. Don't learn the previous values, no use, है ना? UPSC will ask you the current values. So currently for district forum you can file a complaint for up to rupees 1 crore, state level from 1 to 10 crore, and national more than 10 crore. Earlier there was no specific provision to file complaint against e-commerce companies. Now it has been specifically mentioned. It is not that earlier you could not have filed a complaint. Earlier also you could have filed the complaint, but specific provision was not given. It was a 1986 Act. Okay, now it has been explicitly mentioned. Earlier there was no mention of product liability. What does this mean? Suppose you have purchased a ballpoint pen, okay, and the pen leaked and damaged your shirt. Okay, your shirt got damaged because the pen leaked. So earlier the company would say that the value of our pen is 10 rupees. At max we can compensate you 10 rupees. Okay, but now if you have the right to say that your pen, the malfunctioning of your pen has caused damage to my 1000 rupees shirt, therefore you as a company should pay me 1000 rupees. So this is the concept of product liability. Okay, na? So this product liability has been specifically mentioned now in the Act. Earlier it was not mentioned in the Act, but after various court rulings it was allowed. Product liability was case to case basis allowed. Mediation provision has been introduced now, and video conferencing has been introduced, right? Some additional points about this Act. This central authority, it can conduct investigation or it can order recall of unsafe goods. So this recall of unsafe goods mostly comes in news in the context of automobile sector. Many a times, many automobile companies, after launching a new model, a new car, after few months, some of them have recalled the car, saying that if you fill the fuel tank up to the highest level, then there are chances that in certain situation the fuel may leak out, or the airbags are not working, right, or the brakes stop working under certain situation. So the company recalls the cars, fixes them free of cost. Okay, na? So that is a recall. Now in this case it is given that this central authority can also order recall if the company itself is not doing such a thing, if there is some unsafe product, right? And if there is any misleading advertisement, and this authority can itself, suo motu means it can itself initiate some class action suits. So class action suit simply means that if a large population has been affected by a similar grievance, then those large population, each individual cannot be expected to file a separate case, right? So this authority on behalf of thousands and lakhs of people will file the case, right? Then like you can take an example. Suppose you have this bread, okay, this normal 30 rupees bread that we get. Okay, suppose that bread company has not followed some things and some regulations, and in their bread there was some element which has caused, let us say, health issues in a large population. So lakhs of people will not be suing the company, rather this authority will sue the company on behalf of those lakhs of people. So that is a class action suit. So once you file an application, within 21 days it has to be decided whether they are admitting this application or not. District and state commissions can review their own orders, and suppose you have a problem with a product from suppose you have purchased a mobile phone worth rupees 10,000. It was faulty, company is not exchanging it, and you went for the consumer forum. So the value here in question is 10,000 rupees. Okay, na? So for such small amounts, that is up to 5 lakh rupees amounts, you don't have to pay any fee. Okay, so 2012 question was, when a consumer files a complaint in any consumer forum, no fee is required to be paid. This is wrong, right? Not no fee on all cases. Okay, it is no fees only till 5 lakh rupees. Consumer protection e-commerce rules. So who issued these e-commerce rules? It is a Ministry of Consumer Affairs. Okay, UPSC can say that Ministry of Information and Technology has issued this. So be careful. It also applies to any foreign company. If you have purchased things from any foreign company which is selling in India, that is also covered in this. It applies to both marketplace and inventory model systems. What are these inventory and marketplace models? So this question can actually come as a standalone question. So see what this is. Suppose this is a manufacturer, a factory. Okay, from factory some goods were supplied to, let us say, Amazon. Suppose, okay, this is Amazon. This is a warehouse of Amazon. So Amazon in bulk, they purchased from that company. Amazon has purchased and kept those things in its warehouse, and whenever you order those things from Amazon from its store, it supplies to you. Okay, this is inventory model. Amazon is maintaining an inventory of goods. Okay, another model is that Amazon is just a website. Okay, in this case what will happen, suppose now we will see the marketplace model. In marketplace model, this is your internet. Okay, now you open the Amazon's website. Amazon is just a website. Amazon is connected to many suppliers. Okay, there are thousands of suppliers in the market. These thousands of individual suppliers source goods from different manufacturers and keep with them. Our Amazon here is just a website. It allows these sellers to mention on their on the Amazon's website that what product at what price they want to sell. Right, so here Amazon is acting like a market. Amazon is not purchasing goods from the manufacturer. This is a marketplace model. Okay, so whether the online order you are giving, whether that company is working on a marketplace model or it is working on inventory model, to both such cases these rules will apply. And of course the websites must mention what is the country of origin of that good or service. Money bill. See, money bill basics you already know, है ना? So still let us revise some important things. So money bill has been discussed in articles 109 and 110 of the Indian Constitution. Money bill can be introduced only in Lok Sabha. Then it goes to Rajya Sabha. Rajya Sabha can recommend some amendments, but Lok Sabha is not bound. Lok Sabha may accept the amendments given by Rajya Sabha or it may not. If Rajya Sabha does not take any decision within 14 days, then it will be assumed that Rajya Sabha has passed the bill, the money bill. Okay, that is written in Article 109. Now, Article 110, it tells what do we mean by a money bill. See, the language, if you read the actual language of 110 article, obviously it is complicated and it is a very technical legal language. But for exam purpose, I would suggest to you that just remember that if government introduces a bill which deals only with these matters, with no other matter, if a bill deals only with these matters, then it will be a money bill, and the speaker has to give a certificate that yes, I certify that this particular bill is a money bill, it deals only with these matters, right? So speaker's decision is final, however it can be challenged in Supreme Court. Now what are these matters? These matters are taxation, okay, borrowing of money by the government of India, not by the states, by the government of India, anything that has to do with Consolidated Fund of India, Contingency Fund of India and Public Account of India. I want to emphasize again, if the bill is dealing with any of these matters and also with some other matter, then it will not be a money bill. To be called a money bill, it should not deal with any other matter, it should deal only with these matters. Fine. Now if you read your Lakshmikant, it says that there are 3 types of financial bills. Okay, our constitution talks about 3 types of financial bills. One is money bill that we just discussed. Another is finance bill category 1 and finance bill category 2. What is the simple difference between them? The simple difference is the bill that has been introduced, if it deals only with the matters given here, with no other thing, only with these matters, then it is money bill. However, if it deals with other matter also, with any of these matter and some other matter also, then it will be called as a finance bill category 1. Okay, and third will be finance bill category 2 is that bill has no provision of, that bill does not touch any of these things. However, it has some impact on the expenditure of the government. Okay, then it will be finance bill category 2. Now I have compared them. For example, if you want, you can learn them for prelims. If you want to leave, you may leave also. What is important for prelims is the money bill. Okay, these 2 bills are not much important for prelims, but this is very much important. Okay, still I will just tell you the comparison, simple comparison between them. Money bill can be introduced only in Lok Sabha. Finance bill category 1 only in Lok Sabha. Okay, finance bill category 2 in either house it can be introduced. To introduce money bill and finance bill category 1, you need president's recommendation to introduce it. However, category 2 finance bill, to introduce you don't need president's recommendation, but once introduced, if you want to discuss it, if you want to consider it, to consider the bill, you need president's recommendation. Fine. How is a money bill passed? I explained to you. Lok Sabha will pass it, Rajya Sabha may amend it, but that does not matter. Ultimate, it is a Lok Sabha that decides everything in case of money bill. However, finance bills are just like any other ordinary bill, right? Joint setting is not permissible for money bill. For other 2, yes, joint setting is permissible, right? Now, when a money bill has been passed by the parliament, then the president may give his assent or he may refuse to give his assent. Okay, withholding assent. Okay, withholding assent does not mean that president is saying yes or no, or he's delaying the matters. Withholding, some people think that withholding means delaying the matters, using the veto power. No, that pocket veto is different thing. Not taking any action is a different thing. Withholding assent means saying that I am not going to sign it, right? Either you give their assent or you refuse to give your assent, right? President cannot return for reconsideration. President will sign or he will say I'm not signing. He can't say to Parliament, please consider it once again. That thing is not available here. Okay. For the other two bills, President can return it for reconsideration as well. So that's the main difference. Now let us see the previous year questions on money bill. 2018 question. About the money bill, which of the following are not correct? See, technically, all the four statements are correct. All the four statements are correct. Okay. Still, UPSC gave the answer as C. The reason why UPSC gave the answer as C is, see, the paper setters are also humans like us, na? So sometimes they also make some mistake. So what mistake they made was, if you open article this 110 and you read where these things are given in the article, there is a statement there. Money bill is concerned with appropriation of monies out of Consolidated Fund of India. The sentence in the Constitution is this sentence, exactly sentence C, but instead of contingency there is consolidated. So the paper setter changed a few things. Instead of consolidated, he changed the word contingency fund of India, and he thought hence the statement has become wrong. So answer C is, this third statement is wrong. However, if you read other provisions of article 110, then this third statement also becomes correct. Okay, so that was the fault of UPSC paper setter. That is not your fault. For exam, I would suggest you, instead of learning whole article 110, simply learn that if a bill has got something to do with only with these matters, then yes, it is a money bill, right? You can prepare for mistakes done by UPSC, right? 2015 question. Rajya Sabha has no power to reject or amend money bill. Correct? Yes. Rajya Sabha can only suggest that please amend this. It has no power to do such a thing. Okay, it can only suggest a thing. It is up to Lok Sabha whether it accepts the amendment or not. Rajya Sabha cannot vote on demand for grant. Yes, that is absolutely correct. Rajya Sabha cannot vote on this. Third sentence is Rajya Sabha cannot discuss the budget. Rajya Sabha can discuss. See, budget, about the budget, annual financial statement is the budget. Rajya Sabha can discuss the budget, but it cannot vote on it, right? So statements 1 and 2 are correct. Prelims 2013. What happens if a money bill is substantially amended by Rajya Sabha? UPSC is trying to confuse you by using the word substantially amended. It doesn't matter whether the amendment is small or large. Okay, Lok Sabha is free. Lok Sabha can proceed with the bill. It doesn't matter what the Rajya Sabha has said. So option A is correct. Prelims 2000. Incorrect statement. Money bill can be tabled in either house of parliament. No, money bill can be tabled only in the Lok Sabha. Lottery, gambling, betting. See, lottery for prelims, just remember few facts. That when the central government or the state government organizes lottery, then that thing is included in the union list. That is written in the union list, right? However, some private company can also organize a lottery, है ना? So in that case, the state government has the power to ban it. So in Karnataka, suppose there is some private lottery by some company, some private company, है ना? So you cannot say कि sir, lottery word is given in the union list, so how can Karnataka government ban the lottery? No. That is by the private company, na? So that state government can ban. If the central government or state government is organizing that lottery, then that is in the union list. Fine. About betting and gambling. Betting and gambling are written in the state list in the 7th schedule. Okay. There is a central law, Public Gambling Act. However, it is a very superficial act. The real power to make laws on gambling is with the state governments because it is a state subject. Okay. So some states allow gambling, some don't. Okay, na? So it depends on the state. So for prelims, UPSC will simply say a sentence that while lotteries are allowed, betting and gambling are considered as sin and hence banned throughout India. UPSC will give some extreme statement, है ना? So don't fall for any extreme statement. All three are legal and it depends from state to state also. See here, Supreme Court has said that lottery, gambling and betting are taxable under GST. Okay, so these are not illegal activities per se. State government can make them illegal by enacting a law. Remember that FDI is not allowed in either of them, right? India has liberalized FDI. In almost every sector FDI is allowed. There are only handful of sectors where FDI is not allowed, and these three, lottery, gambling, betting, is one such sector where FDI is not allowed. FEMA and FCRA. See, the keyword here is exchange management, foreign exchange management. Here the keyword is foreign contribution regulation. See, this is India. Okay, you are here. Your brother is currently in UK for studies. He is doing his MBA from there. You are sending him money. ठीक है ना? Right now you are sending him money. You are hoping, and maybe after a few years when he gets a job there, he will send you some money as remittances because you are his elder brother. So here the foreign exchange is involved, and that is quite obvious. So such transactions are managed under the FEMA Act, okay, because we don't want volatile rupee. Suppose currently the rupee dollar exchange rate is 75 rupees for $1, है ना? So now government, there is partial convertibility of rupee. It is not that today you take thousands and crores of rupees and say I want to convert it into dollars. You can't do that. There have to be some regulation because otherwise there will be high fluctuation in this rate. So such management of foreign exchange is managed obviously by the Finance Ministry or the RBI. Fine, that is the purpose of this act, to facilitate external trade and payments. However, suppose in South India there is Kudankulam nuclear power plant, and Russia is building that. Russia has built that. Now maybe USA, there is some company in USA which does not want that power plant to succeed. So what USA will do is, USA will encourage one of its NGOs. USA will encourage to donate, to give money to some NGO in India. And that NGO in India will use that money to generate public opinion here that nuclear power is bad. We should not allow this nuclear power plant. It is against the environment. It is against this and that and everything. So there will be public protest and government will bow down to the public pressure, and government will say, okay, we are suspending the construction of this Kudankulam nuclear power plant. So that is a wrong thing. To control, to prevent such things, there is a regulation on the foreign contributions, right? So it is a matter of national security. So Ministry of Home Affairs looks after such things. The aim of this act is to control the inflow of foreign funds to NGOs and other people, right? So details of these acts will not be required. If you use your common sense and you are clear about these concepts, then you will be able to tackle any question that UPSC may frame in the prelims. Next thing in news was Mission Karmayogi. Look, Mission Karmayogi is nothing but like your MOOCs course. What are MOOCs courses? These are massive open online courses. Like you have websites like edX, edX.org or Coursera. You can do, thousands and lakhs of people can do online courses there. Such are MOOCs courses. So basically, if you want to get trained, if you want to learn some skill, you don't have to go to your nearby college and learn those skills. You can simply open your computer, you can do an online course. So nowadays all private companies provide such facilities for online training. So government was already providing some online training facilities. Now government is trying to more institutionalize such online training. Therefore that program is now called as Mission Karmayogi. Simply it is online courses for civil servants. Okay, the official name of this Mission Karmayogi is National Program for Civil Services Capacity Building. What UPSC can do is, in the question UPSC will not use the word Mission Karmayogi. It will use which of the following are true about National Program for Civil Service Capacity Building. And you will think, what the hell this program is? I have never heard its name. Okay. So the online portal like edX portal is there. So similarly, for this Mission Karmayogi, the courses will be provided through the platform called as IGOT platform. IGOT is Integrated Government Online Training. Okay, it is not a new portal. If UPSC says that IGOT portal was launched last year along with Mission Karmayogi, no. Okay, this IGOT portal has been in existence for many years. Anyone can enroll for this Mission Karmayogi? No, it is only for government employees. Okay, which is a concerned department or ministry? It is the DOPT, Department of Personnel and Training, under Ministry of Personnel, Pensions and Grievances. है ना? Public है ना? That I don't remember the full name. PP and PG. This is the correct name. Personnel, Public Grievance and Pensions. Something like that. Okay. So I think some institute erroneously, by some mistake, they had said that Mission Karmayogi is not under DOPT. Some institute was telling this. That's wrong. Okay, I have confirmed from website, from ministry website, Mission Karmayogi is under DOPT. Please remember that. What is National Career Service? National Career Service is just a job portal like Naukri.com. Okay, it is through Ministry of Labor and Employment. Now it is also providing some training and counseling facility. You are seeking a job, not government job. You just want any job. So you can register yourself on this website, National Career Service. Then private company players who want to recruit people, they will register themselves on this, just like a job portal. Okay. So there was a previous year question on National Career Service in 2017. It is initiative of DOPT. No, National Career Service is about Ministry of Labor and Employment. So first is wrong. Second is, NCS has been launched in a mission mode to improve employment opportunities to uneducated youth. Yes, National Career Service is a job portal. It will help in the employment opportunities for the youth. But what type of youth? Educated or uneducated? Of course educated. If you are going to register yourself on Naukri.com, you can't say I'm uneducated, I'm illiterate, please give me some job. No, it is for degree holders who are 12th pass or degree holders, postgraduate and something like that. Okay, so it is only for the educated youth. Here UPSC is saying uneducated youth. Fine. Otherwise also you can think कि uneducated word here he is using, and here it is saying National Career Service. मतलब uneducated and illiterate people, for them government will use some career word. Government will make their career. I think no. Okay? So that's how also you can think. National Recruitment Agency. So it is also initiative of DOPT, just like Mission Karmayogi. Okay, it will conduct common eligibility test twice a year. It is only for non-gazetted post, not for gazetted post in central government, and there will be different levels of exam. Like most of you would have appeared for your SSC exams. SSC also there are exam for CHSL and CGL, different levels of exam. Similarly, it will have different level of exams. It will be in 12 languages. Most of the central government recruitment exams right now are in English and Hindi, but now it will be in 12 languages. Sorry. And the score will be valid for 3 years. How can UPSC confuse you in this simple thing? Either it will confuse you with the ministry, or it will say that it will be a national level exam. Candidates will have to appear in a single exam and they will get the job. That is wrong. It is a screening exam. It is like a shortlist. For example, in CGL also there are 3 levels. Tier 1, Tier 2, Tier 3 suppose. And in some other exam also there are 3 levels. Some other exam also there are 3 levels. What this CET will do, it will be common for the first level of all these three, but the next, second and third level respective agencies will have their own exams. Okay, so you will not get the job simply by appearing in this one exam. Aadhaar. See, for Aadhaar, government brought some amendments a few years ago, but government brought it as a money bill. Okay, so I've already explained to you what is a money bill. So if you properly read that, then it is quite obvious that what government did was wrong. It was not a money bill, but we know nowadays Supreme Court how independent it is. So Supreme Court said कि नहीं, government has brought it as a money bill. Yes, it is a money bill, and we won't review the judgment. Okay. So for exam, you just have to remember the basics of Aadhaar. What kind of data they are collecting? Demographic and biometric. Demographic means your name, your date of birth or age, gender and address. So UPSC can ask in prelims which of the following data are collected for Aadhaar registration. So learn them. Okay. Name, date of birth, gender, address. Biometrics, your 10 fingerprints, your eye scan and your photograph. Okay. For which things Aadhaar is required and for what it is not required, that was outlined by Supreme Court in its judgment. Okay, so for filing your income tax return, to get a new PAN card, for any welfare scheme, Aadhaar is required. Welfare schemes like PDS, NREGA and etc. Fine. However, if you want to open a bank account, then there is no need to give Aadhaar. Okay, to get a new SIM card. If you want a Jio SIM, then they say कि नहीं भैया without Aadhaar card we won't give you a SIM card. है ना? They always say this, but actually it is not required for school admission. I have personally seen some schools which they are putting on their main gate that Aadhaar is compulsory to get admission in this school. That is a clear violation of Supreme Court guidelines. Okay. Then registration for birth and death, Aadhaar is not compulsory. UPSC can ask what is virtual ID for Aadhaar. See, Aadhaar is a 12-digit number, but the virtual ID is 16-digit number. So some people had concern that when we authenticate Aadhaar online, we have to disclose our actual Aadhaar number. We don't want to disclose our Aadhaar number. So government said fine, you download this Aadhaar app and you generate a temporary 16-digit number. You use that 16-digit temporary virtual ID for authentication purpose, and once that authentication is done, that number is no longer useful. So your authentication purpose is done and you did not have to disclose your Aadhaar also. Okay, so just remember it's a 16-digit virtual number and you can generate it again and again, right? How many whatever quantity you want virtual ID, every day you can generate a new virtual ID. Okay, there's no as such special restriction on this. UPSC can ask that to authenticate, suppose you have got your Aadhaar number made, you got your Aadhaar card, now you want to authenticate, so how do you authenticate? You give your thumb impression, or you get a OTP online. When you enter your Aadhaar number, you will get a OTP on a registered mobile number and such things. However, there are other ways also to authenticate, right? Aadhaar can be authenticated without biometrics. Such process is called as paperless offline eKYC. It's a very misleading word. So what happens here is you are having a computer. Okay, you open your computer, visit Aadhaar website and you download a file. Now you upload this file on any other server, that on any other company that wants to authenticate your details. So it's a bit lengthy process. You have to download a XML file. So in this way your actual Aadhaar number is not disclosed, and whenever you want you can download the file today and you can upload it on that website tomorrow also. Okay, so such thing is paperless, and although it is using internet, still UIDAI calls it as offline eKYC. Fine, so just remember that this term is related to Aadhaar and you can authenticate it without biometrics. If there is any dispute, then which is a tribunal? The tribunal's name is Telecom Dispute Settlement and Appellate Tribunal. So learn this, okay? So complaints against UIDI, if you have any problem, you can go to this tribunal, that is Telecom Tribunal. All these things were done by the 2017 Act. In Finance Act 2017, a lot of tribunals were merged. Okay, I think this thing also happened that time only, if I'm not wrong. Anyways, 2 previous year questions on Aadhaar. Prelims 2018. Aadhaar can be used as a proof of citizenship or domicile. No, Aadhaar is not a proof of citizenship. Aadhaar is a proof of identity, right? Once issued, it cannot be deactivated or omitted by the issuing authority. Wrong, it can be. Many times some people somehow got duplicate Aadhaars, so UIDI has, which is the issuing authority, it has deactivated many Aadhaars. So both statements are wrong. Another question. Aadhaar provides open APIs, API application programming interface. What does it imply? It implies that it can be integrated into any electronic device and online authentication using iris is possible. What is API? See, suppose take an example that you call any customer care. Suppose your internet is not working, your broadband is not working. You call up their customer care executive and you talk to them. You tell that this light is not working, speed is slow or whatever thing. So you are interacting with a person, with a human being, and you are using English or Hindi or any language. You are using some language because there is interaction between two humans. Similarly, when two applications need to talk to each other, then there has to be some language, some common language. So such common language or interface you can call as application programming interface. What happens here is that this is the, let us say, server of Aadhaar, and here you have some application which needs, it is some company which needs which interacts with people. People fill their Aadhaar details and this company's server needs to be in contact with the server of Aadhaar, UIDAI. Okay, so how will these two things work? Through API. If you want to develop a new, if there is a bank, suppose, okay, a bank wants to give you a facility that you can open your savings account online within 5 minutes through Aadhaar authentication. Now, how will that bank create such a platform? On their online portal, they will include some software which will use API. That API will be used to authenticate data from Aadhaar platform, right? Some things about Aadhaar that UPSC can confuse you. UPSC can say that Aadhaar is a 12-digit number issued to Indian citizens. No, it is issued to Indian residents. However, NRIs can also get Aadhaar. NRIs are not residents. Still, they are allowed to get Aadhaar. Fine. UIDI is a statutory body. Yes. However, it does not come under Home Ministry. It comes under MeitY. Right? UIDI is not exempt under RTI Act. RTI applies to UIDAI. Blue Aadhaar is issued to whom? No, it is not issued to handicapped people. It is issued to children up to 5 years of age. Aadhaar PAN linking is compulsory. However, the deadline is being extended by the government again and again, right? But the linking is compulsory. Now the prelims 2020 question. See, the Supreme Court ruling that I told you here, that Aadhaar is a money bill, is okay. So there's many things Supreme Court has said. Many changes in the Aadhaar Act Supreme Court made. So what Supreme Court said was that the authentication data of Aadhaar cannot be stored for more than 6 months. The Act gave a provision that authentication data can be stored for 5 years. Supreme Court said 5 years no use, store it only for 6 months. So UPSC said it to be 3 months. Okay, so option 1 is wrong. State cannot enter into any contract with private corporation to share Aadhaar data. This is correct. Okay, that is what the Supreme Court said in its ruling. Aadhaar is mandatory for insurance products. No, it is not mandatory for insurance products. It is mandatory for getting benefits funded from Consolidated Fund of India. Yes, that is right. It is all written in the Supreme Court ruling. You don't have to learn the ruling. I think the substantial points have already been covered here from the ruling. So just learn this question in case UPSC wishes to test this thing again. See, here we had this now. It is required for welfare schemes like PDS, Narega, because all these expenses come out of Consolidated Fund of India. Whistleblowing. Whistleblowing means that something wrong is happening, be it in the government, be it in the private sector. Okay, if you're in the private sector and you see that your company is doing, that someone in your company is doing something wrong, and it is not an individual person. Okay, in your company there are some high level managers in a group, they have adopted some policy which is harming the society, which is against the government rules, then you can blow the whistle, right? According to Companies Act, listed company means those whose shares are being traded on the stock exchange. So such listed companies, they must have committee to investigate in case there are any whistleblower complaints. SEBI rules also prohibit whistleblowing. I'm sorry. SEBI rules also encourage whistleblowing for those who expose insider trading. Now, what is insider trading? See, sometimes you would have read in newspaper that shares of some company jumped like 20% in one day. In a single day, a company share jumped 20%. Why do you think such a thing happens? It happens because some sudden good news would have come about that company. Maybe that company has got some big order, or that company has got a good deal with some other country, with some other company. Now such big news never happen in a second. There's a lot of planning, there are a lot of meetings between two companies, there are a lot of discussions, and then finally the company wins the bid and something like that. However, for the public, such news comes in an instant. Okay, so suddenly there is a news flash that such company has got such a big order, and suddenly people will start buying its shares and the price will shoot up. Now the problem is that the insiders of the company, people who are working inside the company, who have the knowledge about the negotiations, if a person who is involved in the negotiation, he is pretty confident that the deal will go through, the deal will be successful, and hence our company stands to gain. That person knows that when this information about the successful deal comes in the market, people will buy the share price will increase. Therefore, that person, beforehand itself, that person buys lots of shares of that company. Because he has some advantage. He knows some information that you and me from general public does not know. That is called as insider trading. He is an insider of the company and he trades in the share due to some information that he is privy that we don't know. Such a thing is illegal. There should be level playing field between everyone. So if you know that someone is doing insider trading, you blow the whistle, you tell it to the government, then according to SEBI rules, you are protected. Anyways, our concern here is about the government. Okay, for government has brought this Whistleblowers Protection Act 2014. It protects, if you blow the whistle, this act will protect you against victimization. You can blow the whistle, you can expose the corruption or misuse of power by any official or ministry. Okay, the whistleblower who is going to expose the corruption, either it can be a government official, suppose you are also working in some government organization, be it on a small level, but you know something, some corruption, okay, you have some information about that, you can complain. Okay, sometimes you are not working in the government, you are an individual or an NGO, and you have come to know about corruption that some government officials or ministers are doing, then also you can blow the whistle. Fine. And again, what we learned in the RTI thing, that information protected under Official Secrets Act can also be disclosed if public interest is being served. Okay, this act, whistleblowing, does not apply to armed forces. Obviously, army is always, secrecy is a great weapon of armed forces, and you don't want whistleblowers to, expose the secret meetings and everything. Now, in 2015, government tried to amend this act. Okay, but that amendment bill lapsed because that amendment was hugely controversial. That was said that that bill will like kill whistleblowing. Okay, that was a very dangerous thing, just like RTI wali amendment thing, 2017 wali, that if you die while filing an RTI, then the RTI application will end itself. So similarly, this was also a very dangerous thing. In 2015 UPSC mains exam, UPSC put this question that if the proposed amendments to Whistleblowers Act is passed, then no one will be left to protect. Okay, so CrPC was enacted in 1973, though initially it was created in 1882. IPC was enacted in 1860. See, in 1834, under Macaulay, when the first law commission was formed, it recommended that we should have an Indian penal code. However, it was only in 1860 that IPC was enacted. Okay, now what is the difference? Difference is pretty simple. See the word here, procedure. So it tells the procedure, that what procedure you will follow to investigate. Police will investigate the crime. What procedure the police has to follow, right? After that, the court case will be there. In court case, what will the court see? How will the court determine whether a person is guilty or not? Okay, so that is CrPC. Then IPC, it is penal. So penal means penalty. You are going to tell the what is the penalty or the punishment for the crime. So first police will investigate, then the court will say that yes, you are guilty. Then court will say, okay, what punishment you will be given. It tells what is a crime and what is its punishment. Right to internet. So in Fahima Shireen case, Kerala High Court said that right to access internet is a part of right to education. If you want education, then obviously a good part of education today comes through internet, and it is also part of right to privacy. So this case was basically of Kerala, that a girls hostel had restricted access to internet to girls, saying that girls will get spoiled if they use internet in the night. Okay. So question can come that when government issues orders to restrict internet, so under which law are such orders issued? The order can be issued either under the Telegraph Act 1885 or under Section 69A of IT Act 2000 or under Section 144 of CrPC. Okay. Now please note, I am telling you Section 69A of Information Technology Act. It is not Section 66A, because 66A was struck down by Supreme Court because they were quite misused. Anyone who tweeted anything against the government used this section to put case against that person. So Supreme Court said that this section is being misused. It is wrong. We are striking down this section. Now government is using other sections to punish people who are speaking against the government. Competition Commission of India. Competition Commission of India. What is the purpose of it? See, today there are three different companies: Airtel, Jio, and Vodafone Idea. Now there are three companies. If one company is not providing you good service or charging too much, you can always migrate to the other companies, because there is healthy competition. There is choice available to you. However, tomorrow if Airtel closes down, Vodafone Idea closes down, and there is only Jio, then Jio will have practically the monopoly in Indian telecom market. That monopoly is not good. So competition is always healthy. It is a customer who wins when there is healthy competition. The work of Competition Commission of India is to ensure that there is healthy competition in the Indian market in different sectors. right? It prevents activities that reduce competition. For example, when there was Facebook Geo platform deal, when Facebook was purchasing some stake in the Geo platforms, then you have to take, they took permission from CCI, ठीक है ना? Similarly, it penalized, actually a few years ago CCI penalized Google with 136 crore rupees for abuse of dominant position, ठीक है? तो basically see, the thing here is that tomorrow Jio becomes quite big. Suppose Jio gets, let's say, 60% market share and Vodafone Idea and Airtel are quite small, ठीक है? Now obviously when Jio is controlling 60% of the market, and suppose it takes any steps which are at disadvantage to Airtel or Vodafone, which may force these companies to close down or which may exploit the customers, then in that case Competition Commission of India can take action, ठीक है? So it's a very powerful body actually. Just remember its purpose and remember that it is a statutory body under Competition Act 2002. Already there we had an act, Monopoly and Restricted Trade Practices Act 1969. So this 2002 Act actually replaced that 1969 Act. Also remember that predatory pricing is illegal under Competition Act 2002. So what is predatory pricing? So it is mainly that, suppose when Jio came, ठीक है, Jio would offer services at such a cheap rate that Vodafone Idea and Airtel would have closed down, है ना? So that was predatory pricing. Suppose Jio would have done anything like that, so those things are not allowed, because you are basically because with such a thing you would actually be killing the competition. Okay, so such very low prices, if something is available for, let us say, a mobile is available for rupees 10,000, okay, and tomorrow Flipkart says that we will sell 10,000 rupees mobile only for 2,000 rupees, so that only this mobile sells, no other mobile sells, okay? So such predatory pricing is illegal. Public distribution system. See, the object is simple, that public should get distribution of essential goods at affordable price on time, ठीक? Now what is sold through PDS? Central government gives rice, wheat, sugar and kerosene. Learn these four things: rice, wheat, sugar, kerosene. These four things central gives to state governments. State governments in addition can give other items also, like salt, oil, spices, pulses, etc. through the ration ki dukan, ration shops. Fine. The responsibility of center is to procure. Central government procures through FCI, Food Corporation of India, mainly, okay? The central government will procure, store and transport and allocate to the states. State government will identify the beneficiary, issue the ration card and supervise the fair price shops. A very brief history of the PDS system in India. So during World War II there was shortage of goods. That time government made some regulations on distribution of essential commodities. In 1960s, when there was severe food shortage, then this existing PDS system got attention. After Green Revolution, government said that we should extend this system to tribal areas. Major shift came in 1992 when revamped PDS was launched. Government said, where do most poor people live in India? Most poor people live in remote areas, right? So it was a area based approach. Government's focus from 1992 RDPS was that we should focus on backward areas, right? In 1997, government said our focus is not on the backward areas, our focus is on backward people. That is, our focus is on the poor. Wherever that poor might be living, we will try to get cheap food to that person, okay? So this targeted PDS was launched in 1997. It was mainly for the below poverty line people. However, Government also provided to above poverty line people. However, the rate was higher. Okay, if a BPL family is getting something for 1 rupee, then the APL family will get it for rupees 5, suppose. Why was government giving to APL people also subsidized food grains? Because if a person is in BPL and he's getting food grains at cheap rate, it is good. Now tomorrow when his income increases, then suddenly he will not have any support from the government. So he will always want to remain poor. Not a good thing. So therefore government said that to APL also we will give, but it will be not as much subsidized as is for BPL. In the year 2000, government launched Antyodaya Ann Yojana to target the poorest of poor in below poverty line people. During the 12th 5-year plan, that is from 2012 to 2017, government initiated a scheme called as end-to-end computerization of targeted PDS operations. See, targeted PDS, PDS has been since independence, but it has evolved. Now through this plan scheme, what government said was that we are going to computerize, we are going to digitalize all the fair price shops, all the ration ki dukan, all ration shops will be computerized, so that we can see in real time how much quantity they are receiving, each ration shop how much they are receiving, how much they are selling to which person. There will be EPOS. EPOS is point of sale. When you go to big bazaar or any big shop, when you check out, you see that they scan it and they give you a billing. That is point of sale. Okay, the moment they sell a thing, their inventory gets updated that such and such material have been sold, inventory has been reduced. Okay, there will be Aadhaar linking. The beneficiaries, their Aadhaar will be linked to their ration card. Okay, all these things were done, initiated through this scheme. In 2018, government launched integrated management of PDS. Through this, the target was the nationwide portability of ration benefits. Under National Food Security Act 2013, people get cheap food grains through their ration shops. Now ration shops are being digitalized. So now when ration shops are being digitalized, obviously you can pick your ration from any other ration shop also, because there will be a central record. So slowly under this program, first government digitalized them, then government is adding state governments in this central system. Now government is saying that when majority of states will be added to this central system, then we will call it as one nation, one ration card. That you can get your ration benefits from anywhere in India. However, government has put some restriction that a migrant, suppose a migrant is in Bihar, okay, a person is originally from Bihar, okay, his family is still living there and he comes to Delhi, right? So from Delhi FPS shop, ration dukan, he can get 50% of his quota, and 50% of the quota can be taken by his family in Bihar. Okay, so both can enjoy the benefits of cheap ration. Acha, one thing you should remember, that this integrated management of PDS, it is for interstate portability. Okay, from Bihar to Delhi, suppose. Government also has a Anna Vitran portal, that is for inter-district portability. That within Bihar, you go to some other district and you are able to take your ration benefits. That is through Anna Vitran portal. IMPDS is for national portability. National Food Security Act 2013. It made cheap food your legal right. See, cheap food had always been given through these programs. Now, what is the use of making a law on this? Just an eyewash? No. See, please understand, this is very important. When lockdown was imposed last year, then migrants had to go to their villages. They had no option, right? When migrants went to their villages, obviously there was no work in the villages as well. Still, migrants were able to survive. Why? Because there was Manrega. Manrega is not a scheme. People think that Manrega is just a scheme. Modi ji launches scheme after every 6 months. Fancy names. So Manrega is also a scheme. Just no. Manrega is a law. Okay. Government is not above the law. Government is bound by the law. When migrants went to their villages, they had the assurance that they will get some work, else government will pay them the money. You would have learned that government allocated record money to Manrega. Government has not done some favor by giving you money. Okay, it is your right. That right was given to you by the Manrega Act. Similarly, here cheap PDS food grains you already got. We always were getting this. But through this act, it has become our right. And this right cannot be violated, else you can go to the court. Fine, that is the importance of act and not just schemes. This NFSA benefits 75% of rural India and 50% of urban population. Rice at 3 rupees per kg, wheat 2 rupees per kg, coarse grains at 1 rupees per kg, 35 kg food grain per household per month. Simple figures, you have to learn them, can't help in this. And important thing is that the eldest women family member is considered as the head of the family for issue of ration card. What is the meaning of an electricity prosumer? Prosumer means producer and consumer. Normally we just take electricity, but here we can also generate electricity. Okay, this is your house. You install some solar panels on your house. Okay, whatever electricity is generated from the solar panel, you use it inside your house. Whenever there is some extra electricity generated by this solar panel, that you can supply back to the grid. है ना? Suppose it's a rainy day and there's no sunlight, so you are simply taking electricity from the grid. ठीक है ना? So the electricity meter, it keeps a record that how much electricity you have taken from the grid and how much electricity you have supplied back to the grid. Okay, so it will give you the net bill, that is the net metering. Okay, this net metering is done by smart meters. So smart meters are basically prepaid meters. Okay, normally the traditional system is that how much electricity you have consumed, the bill will come and then you pay the bill. Now smart meters, what they do is that first you pay the bill, okay, and then the electricity company will give okay to the meter, and then meter will allow the passage of electricity to your house. So these are prepaid meters. They allow time-based tariff for better load management. See, in winters, you wake up at 8 a.m. okay, you switch on the geyser for warm water, right, between 8 to 9. Now almost everyone is switching on the geysers between 8 to 9. This overburdens the grid, है ना? Now since you have smart meter, government can say that those people who put extra load not during 8 to 9 but during earlier time like 6 to 7, wake up early, switch on the geyser, then switch it off. Okay, so if you wake up early and you put load on the grid during non-peak hours, then we will charge you, instead of 5 rupees per unit, we will charge you just 4 rupees per unit. So you will be happy. So such things are allowed by use of smart meters. It allows real-time monitoring. Okay, in real time how much electricity which household is using. It allows two-way communication between consumer and DISCOM. DISCOM is the company which sends you your electricity bill. Okay, so it can tell that in real time how much load which household is using and such things. Now look at the 2016 question. Net metering, sometimes seen in news, is related to what? Okay, is it related to solar energy or natural gas, CNG kits or water meters? It is related to production and use of solar energy by the households or consumers. Some constitutional bodies, I've made a small table, like ECI is under which article, what is the purpose? Purpose is free and fair election, right? What are the qualification to become a member of Election Commission of India? No qualification prescribed, है ना? So such table I have made because through table you can easily learn the things. Similarly, these are constitutional bodies, and here are some statutory bodies. Okay, so just compare the things and learn. Now something you have to note, like in CVC, CVC is a statutory body under CVC Act 2003. However, CVC was not formed in 2003. CVC was formed in 1964 on recommendation of Sanathan Committee report. ठीक है? Similarly for Lokpal, Lokpal is a statutory body, not a constitutional body, right? The qualification to be its member is retired Chief Justice or Judge of Supreme Court or eminent person. Eminent person is an important thing you need to note down here, right? So please read these tables and try to learn things. See these comparisons, retirement age and everything, so that you can remember them. Okay, I would suggest that take a printout of this and paste it on your study table, because if you start learning each and everything, it is not possible. Rather, take a glance every day and things will get easier. NHRC. The NHRC Act 1993 was amended by the government in 2019. Some basic changes were made, not very important for exam. NHRC chairperson, earlier only retired Chief Justice of India was allowed. Now any retired Supreme Court judge can be made NHRC chairperson. Similarly, we have State Human Rights Commission. So there also ex-High Court judge can be made its chairperson. The term earlier was 5 years, now it's 3 years. Members with human rights knowledge, earlier 2, now 3. Out of those 3, at least 1 should be women. Okay, ex-officio chairpersons. Earlier there were some ex-officio chairperson of NHRC. Those were chairpersons of National Commission for Scheduled Caste, National Commission for Scheduled Tribe, National Commission for Backward Classes, for Women, for Minorities. Now with this amendment we have also included chairperson of National Commission for Protection of Child Rights and the Chief Commissioner for Persons with Disability. Reappointment. Earlier it was allowed, now also it is allowed, but earlier there was a limit for 5 years in case of reappointment, but now no limit. The person can be appointed again and again and again. Also, now the central government can confer any state human rights commission the functions of a neighboring UT. For Delhi, the cases will be dealt by National Human Rights Commission. One thing you should note that I have noted from the NHRC website is that if some alleged incident of human rights violation has happened until 1 year no complaint has been made, then generally NHRC will not take up that complaint after expiry of 1 year. Okay, if a matter is sub judice, NHRC will not take it up, and there are any service matters, then you go to CAT or SAT for the tribunals. You don't come to the NHRC for service matters. So these things have been taken from NHRC website. If you have any dispute, I suggest please learn them as it is, and you can refer this website, because some coaching institutes say that sub judice matters can be taken up. They can be taken up by NHRC. The point is UPSC goes by the official version. Since UPSC goes by the official version, it is on the official website. Please follow that. National Medical Commission. Simple thing. It replaced the Medical Council of India. It's a statutory body under this act. The aim is to regulate medical education and medical professionals. UPSC can confuse you. It can say that its chairperson is the Union Health Minister. No, its chairperson has to be a medical practitioner. Okay, it proposes 2 types of exams, NEET and NEXT. See, NEET is already there for entrance exam. It also says there should be a exit exam. See, like with most engineers, the thing is that they simply pass their small semester exams and they get their degree. Now government is saying that with MBBS such a thing should not be done. Ki students are just getting passed somehow. There should be some exit exam also. Ki after 5 years you pass this exam, then you will be allowed to do your practice. Okay. There have been some controversy also, that it says that some mid-level practitioners can be allowed to prescribe some medicines. See, medical staff does not mean just the doctors. Okay, there are many other staff also in medical which who through their experience and everything, okay, they are like semi-qualified. They also have quite good knowledge about the medical profession, and for usual illnesses they can give some medicine, but they are not allowed to give medicine. Only doctors are allowed to give medicine. So now here government is saying that some mid-level practitioners, in certain cases they can be given some license so that they can also prescribe medicine to the patients. Okay, rules and regulation have not been framed for this and for next. Till now rules have not been framed. I think within 1 or 2 years government is saying they will frame some rules. Law Commission of India is neither a constitutional body nor a statutory body. It is an advisory body for legal reforms in India. It is formed by the central government for 3 years. The latest one is the 22nd Law Commission. It was formed in 2020. The first Law Commission was formed in 1834 by the Charter Act of 1833 under Lord Macaulay. As I told you earlier, it recommended the codification of IPC and CrPC. However, they were codified much later. In independent India, the first Law Commission was made in 1955 under MC Setalvad, who was also the first Attorney General of India. National Crime Records Bureau. 1986, it is under Ministry of Home Affairs. Bureau of Police Research and Development. 1970, under Ministry of Home Affairs. Okay, so you have to just remember that these two bodies are under Ministry of Home Affairs and the year of formation. I don't think any more details would be UPSC will ask. Okay, so that's it for this class. We will try to very soon start with our economy PT365 as well. So this we have completed polity. In future there will be more current affairs from polity for your prelims, so then again around after one month or so we will start with that as well. So our next target is mainly the economy PT365. Thank you very much. If you want to download the PDF link is given in the description box of this video. Thank you very much.